Hey, happy Tuesday, everybody. I'm glad you got the word out that y'all heard that we've got, I call it special guest. It's not every day that we have the opportunity to pull in Michigan Realtors, Brian Westrin, and we have that opportunity today. And so we are, as I mentioned, going to talk about what Brian and the team has been running into regarding seller's disclosure. I think you're going to bring that from a couple of different perspectives. And then he said, "Hey, is it okay if?" And he has another subject, which I said, "Well, remember, Brian, we call it hot topic." So he's bringing to us the additional ones on top of it. So, ladies, gentlemen, great pleasure that we can welcome Brian Western.
All
It's all
right.
yours, buddy.
Thanks, Darwin. Appreciate it. Hey, everybody. Good to see you all. One of the things that we've really focused on this year, as it relates to sellers disclosure, is sort of kind of looking at it from a totally different vantage point, which is if you are especially now where we're dealing with buyers that are hearing a lot of noise out there about, what the value proposition of even having an agent is. One of the things that we've really zeroed in on is talking to your buyers about the value of the seller's disclosure statement, but also kind of the relative lack of value inherent in the seller's disclosure statement because of the nature of the types of forms you're receiving from sellers. Some of them, we've heard the age old, never having lived in the home and written across it and just passed off as though that's somehow exempt. And then, of course, just sort of relying upon anything that's furnished by the other party in a transaction as a substitution for your own due diligence and inspections. So one of the things that we've really kind of focused on out of the gate this year, we did three different installments on the letter of the law. We did from the buyer's perspective, from an investor's perspective, and from the listing side. So I'm going to share my screen right quick here just to make sure that we can walk through the buyer's perspective piece because I think it's really valuable as a training tool within offices. Let me see if I can get this operating slideshow play from start. There we go. So everybody see that okay?
We're
All
good,
right.
bud.
So one of the things that the buyer doesn't always truly understand is the scope of the seller's disclosure statement. So when we're talking about representing buyers or even working with a buyer as a customer in certain circumstances that we're seeing more and more, making sure that you're not drifting into the capacity of offering agency and advice on a particular defect on the property, but understanding that the form and the scope of the form is very clearly for sales of not less than more than 4 residential dwelling units, but then that the exemptions are purposefully narrow. So many times, buyers and sellers alike think that they understand whether or not they fit squarely within an exemption just because they lack information on a property. The reality of the situation, at least from the listing side, is that oftentimes they are not exempt. They just may not know enough information about a property that they think is meaningful. Unfortunately, that does not exempt them from filling out the form. So the way we've always started it is that understanding that the form is not always required. So if the buyer doesn't receive one or is wondering why they haven't had one furnished, there may be an explanation behind it. But then, of course, they need to understand the the consequences, right? You're seeing more and more right now sellers just electing not to furnish a seller's disclosure statement, even if it's required by law. And then you get into this sort of push and pull behind, oh, well, it is a statutory requirement to furnish a seller's disclosure statement. But the consequence of not furnishing a seller's disclosure statement is not that you're going to jail. It's that you then present that buyer the right to walk from the transaction at any time before closing. Um, the thing that I think is most frustrating, at least within this context, though, is I didn't receive a form, and I, as the buyer, have been educated that that entitles me to walk all the way up to the closing time before, does that substitute me doing due diligence? Does that substitute me engaging in meaningful inspections? Because some of the things that we try to hang our hat on with the seller's disclosure statement really kind of sound in, well, what happens if we have a breach of contract, or what happens if I claim the seller didn't furnish a seller's disclosure form and I claim I have the right to walk away. That doesn't necessarily mean that the seller's not going to sue for breach of contract. And in my view, that's when we start to get this value proposition baked into representing buyers and letting them know that the seller's disclosure statement is a meaningful starting point, but it is not a substitute for your due diligence. And if you want this property and you feel strongly about the competitive process of getting this property, you need to take more everything into account and avoid these things that we're seeing less now, but still on occasion, where buyers are presented with the checklist of all of these different things that they're willing to do to compete. And those things range from waiving inspections, they range from appraisal guarantees, and escalation clauses, all those things that we've seen in the past. I think a buyer's professional who's out there representing buyers and getting them to understand the process would do well to lead with the seller's disclosure statement obviously has value. It gives you a snapshot in time, 99% of the time, and then that 1% is supposed to be, letting the prospective buyer know where that property's been as it relates to water in the basement, any history of infestation. Those are all very valuable things to take from a seller, but at the same time, it's definitely not a substitute for inspections. So,
Say, Brian, just real quick, can I
yeah,
jump in out of curiosity because it
please.
deals with one of the things that you mentioned with never lived in.
Yep.
Uh, in most of our offices, we have the availability of a exemption from seller's disclosure form.
Hmm.
I dare say you're familiar with that.
Yes.
Uh, is what's your thoughts on that? Does that help cover us or the circumstance in any way?
I think it's valuable. I've seen it. We at Michigan Realtors has one in our library, as do many brokerages and local associations. The issue, of course, is you know anytime, whether you have the seller or whether you've got the buyer, um, we always need to make sure that it's the seller who's avowing that they are exempt. I think that that does insulate the brokerage. Again, it's not going to change the fact that if a listing agent, I'm sorry, if a seller decides that they did furnish a seller's disclosure statement, it was complete, or they elected not to because they think they're exempt. They may still claim in their breach of contract claim against the buyer that their listing agent told them X, Y, and Z. And that's where I think that furnishing of the form, whether it's a prove, identify the exemption that you think you fall within, should also probably be accompanied by some contemporaneous notes that you have that talk about where your seller has been on disclosure. You certainly don't want to be the realtor that's perceived as encouraging them not to disclose. In
Perfect.
fact, I'd always like to be the realtor that has to stand up in court that says, at every turn, I urge my clients to disclose what they know about a property because that's always better than discovery. Um,
Disclosure, disclosure, disclosure.
Precisely. And the buyers, I know that there is the tendency right now, especially with the investor piece, right? You've got investors, and God love them, that they do a really important job when they do it well. They invest in these properties, they rehab these properties, and they turn them into a much more habitable state. Um, but there isn't an exemption for that. When I'm that investor, I can't fall within the narrow builder's exemption because that is a builder's exemption that is for a property that's never been occupied. If I'm flipping a property or I'm rehabbing a property, I either have to make a determination that I will fill out the seller's disclosure statement to the best of my ability. And there's a reason why there are unknown and things of that nature. It's to put the buyer on clear notice that these things are triggers to do their due diligence. But on the investor side, we get a lot of pushback on this because they would like to argue that they either fall within the builder's exemption or they fall within this sort of amorphous non-occupant fiduciary exemption, which clearly doesn't apply. But one of the things that I guess I would focus on if I were an investor or I were rehabbing properties is I have to weigh in the balance what not furnishing and obviously basically letting my buyer know that they've got all the due diligence on their side, and oh, by the way, they can also just walk all the way up to closing if they feel like it. They don't need a reason. Versus I can furnish a seller's disclosure statement. I can let the buyer know that look, I've done the work on this. I stand behind the work, but I haven't lived in this property, so I don't know what I don't know. That can still lead up to a fully furnished seller's disclosure statement under the act. I think a lot of times sellers, whether they're investor sellers or they're sort of the next step from an investor seller, where they think that they are not really truly aware of the status of the property. They would do themselves a much better service if they actually just sat down and answered the form honestly. That's
So
probably
Brian,
the
it
biggest disconnect.
it forms one other question, and I almost hate to ask,
Yep.
but let's say we have a child of a seller who has passed, who took care of mom or dad or both of them, and now they've been assigned as the personal representative to settle the estate.
Mm-hmm.
We had the situation where, if I'm right, they would be exempt through the court order as a trustee, and yet they also have personal knowledge of the property. What would be your guidance?
Most, yeah, most of the time, I always try to, um, like really educate the seller on, if they're curious about whether or not they fall within one of these narrow exemptions. Obviously, I think it's more important for them to, just because the stakes are relatively high, to have a breach of contract claim go sideways for them, that they would want to know from their own counsel, legal counsel, that they fit within the non-occupant fiduciary exemption. Because most of the time people miss the non-occupant portion. And that's where you can satisfy, I am a fiduciary to the deceased, or obviously some sort of executor or executrix. I need to be able to, with great confidence, prior to claiming that exemption, run the traps with my legal counsel. I would not want to be the realtor that's advising that they fit squarely within it. I think that that's a fool's errand in a lot of ways, because at the end of the day, as you mentioned, Darwin, many times they they miss the non-occupant piece.
Mhm.
And of course, they have probably lived in the property in the past, so they may know a lot about it. And I just think that they need to make that decision, and it's why the Sellers Disclosure Act is drafted in the way that it is. The only way the realtor firm maintains sort of the insulation and the indemnification of being party to any fraudulent misrepresentation claim or any of the shenanigans that could occur when filling out the form is to allow the seller to take the lead, and the seller needs to seek guidance from professionals that can sound in legal advice. I wouldn't want to be, as I mentioned earlier, that realtor who is viewed as or on the record as advising not to, or
advising that you should.
tax, and
So,
it's you get into the otr issue, Darwin, is vacant land, right?
yeah.
With vacant land, especially if it's inherited, a lot of people they're thinking, oh, well, I've got to disclose. Well, the problem is, of course, is there are vacant land disclosure forms out there, but there is no law that that mandates vacant land disclosure, and there is no law that protects the parties disclosing. So when you're dealing with vacant land and there is a request to disclose, you do so based on more of a negotiation between the parties as opposed to any mandate by statute.
Otherwise, we may not be in the best interest of our seller client to require that they do a disclosure.
Absolutely. Yeah. I mean, I think the seller needs to take the lead on that. And that's another one where they need to understand that the scope of the seller's disclosure on a residential side is markedly different than this idea that I'm going to be selling vacant land, and buyer, you need to be upfront that you need to do your due diligence. That's where, you never know what's underground, of course. And, disclosing some, but not all could put your seller in a position where they have to at least go through the time suck of a court proceeding.
Well, look,
Uh,
and I pulled you off a little bit, but let's put you back on your track again.
Yeah, yeah. So the idea of still coming at this from the buyer's perspective, you rely upon the seller's disclosure statement for what it is, right? But when you have issues that arise in the process of your due diligence, whether it's information gathered from the disclosure statement itself or an inspection report or the buyer's own observations, the buyer does have an affirmative obligation to investigate further. They cannot just say, "Oh, well, that's clearly a problem, and that entitles me to rely," because it's going to come down to what your inspection contingency says. And oftentimes, as we've seen, inspection contingencies are all drafted differently, and some of them demand specific actions by the buyer. Some of them demand specific actions by the seller to keep the binding purchase agreement alive. But one thing that I do note that we get calls on, even at Michigan Realtors legal hotline, still from not only realtors, but sometimes members of the public try to avail themselves of that service, and we have to let them know that we are not able to answer those questions. But they want to know why they weren't told that their property, had specific language about a sex offender that lives nearby, or a suicide that occurred on the premises. All these things they realized after the fact, or of course the one that's most popular right now, the pop-up tax, in the nature of where the taxable value of the property is. It's important for realtors to be able to explain this to buyers and sellers alike, that the form is not a cure-all. It's never been a cure-all. In fact, it's got enough. If we're being honest, we look at the seller's disclosure statement, and year after year, there are attempts to make it a 10 to 15-page document. But right now, it's a pretty short document because it's intended to be read, because the longer it gets, the less likely it's going to be read, but also trigger the ultimate outcome, which is buyers doing their own inspections with, sort of their best interests in mind, and sellers satisfying the statutory obligation with what they know about the property. So some of those things that buyers might like to say, well, I did my inspections and I found out all these things, but I didn't follow up and utilize that information to either negotiate a better outcome on the transaction, or walk away from the property on the basis of the inspection contingency. Any questions about that?
Brian, it brings to mind one quick one, which is also uh, clearing our mind that it's just an inspection, but it's also the time for due diligence.
Yep.
And that's where it's great that you've brought up. the sex offender, the aspect of being able to talk about what are the taxes going to be. As a matter of fact, I had one of our agents call me up and said, Darwin, what do I do? I just got an offer accepted, but my buyer just called and talked with the township and found out what their taxes are going to be.
Yeah.
Due diligence, and that's what qualified to be able to rescind the agreement.
Right. And I think that that's important because there's two sides of the story, right? I mean, the way Proposal A was constructed was you essentially get the benefit, while you're in the property, while you're living in the property, especially if you stay in it for a long period of time. So you've had that. I mean, I think from the perspective of a buyer who's on the fence of where my taxes are going to go, obviously they need to take stock of where they've been and the benefit that they've received with their taxes not going up relative to. And I sound like a local government here. I apologize, but that's the argument: is that on the buyer side, you will have an uncapping, and you will have a new taxable base, and that's keeping a lot of our long-term property owners in their homes right now because they don't want to deal with. They may own the property free and clear, but they don't want to deal with paying more taxes on a smaller house, especially if they're downsizing. So there is a frustrating element to that debate, but I agree. Buyers that don't have a sense that they're going to have a unique tax obligation once the property transfers and the uncapping occurs, that's a big value add that you can bring to the table. And I think the way that you talk about it can, in many ways, give them a little bit more comfort than a holy crap, I just realized this is going to be an astronomical jump in my taxes, because they have to think long term about some of these things, especially when it comes to where their tax base is going to be. All right. So the inaccuracy piece, I really like, talking to clients to say, yeah, if I've made some statement in the seller's disclosure statement, I'm the seller, they have to prove that there was sort of this intent to defraud or to misrepresent. So when I talk about the seller's disclosure statement as non-evidentiary, it's sort of just that. It's I can't hold it up in a court of law and say, Exhibit A, Your Honor, this is the smoking gun, because really what you then have to do is you have to prove that they not only intended to defraud or misrepresent, that they carried on throughout the transaction intending to deceive. So when we're thinking about what buyers should do in the scope of a disclosure that turns out to be false, um, they don't want to just look at the seller's disclosure statement. They also want to rely upon their inspections. And obviously, if it's closed, we've got a totally different scenario. But if it's still leading up to closing and that buyer has decisions to make, they want to rely upon their inspections as opposed to the veracity of the disclosures themselves. Um, and that sort of dovetails with this point that, the form is not intended to be a warranty. It says so in the act. It says so in the form. I sometimes make jokes that, when you're talking about personal property or fixtures, or things that maybe call the fixture might not be called the fixture, the meeting of the minds of the buyer and the seller on some of this stuff. If your seller's disclosure statement talks about certain appliances being in working order, that doesn't necessarily mean that the appliance is included in the sale. I know a lot of the forms that we're using today are pretty holistic in that they try to make sure that everything is intended to be in the sale, but make sure you're also harmonizing that purchase agreement and making sure that your buyers are getting what they expect. And certainly, um, this weird amnesia that occurs with sellers at times when they think, oh well, it's a fixture. It's, of course it's going with the property, until it's move out day, and they decide to go to great lengths to remove something that's been affixed to the property. Or you think you're getting the refrigerator that's got all the bells and whistles, and you end up with the one that I have from college that fits 12 beers and a leftover steak in it. That's not what you want to have for your client. You want to be able to say, hey, we think these things through. The purchase agreement is what evidences what will be included in the sale. So some of these things are probably common sense, but at the same time, we've had enough calls to the legal hotline where they're disputing whether or not the seller's disclosure statement was a warranty on what should have been in the purchase agreement. Any questions on the chat? I think I saw. Oh, all right.
I was
No,
going to say a quick one just popped into the chat that Cindy was under the understanding that suicide did not need to be disclosed in a real estate transaction or real estate rental in the state of Michigan.
correct.
Can you
Yeah.
expand
So
on that?
there's specific language in the occupational code that exempts, or I should say, it exempts liability and takes any liability away from a brokerage from disclosing that information. Same with uh, ghosts and phantasmagorical phenomenons, things that the property may actually be famous for. We're coming up on the fall, and we've done Halloween episodes on disclosures because these very things do pop up. Whether you believe in haunted houses or not, or things that tragically happen in a home, the occupational code makes it clear that that is not a liability trigger. The only thing I would sort of put an asterisk on that is if the if the homicide or suicide in any way damaged the property or created some sort of structural concern, that may also lead to a second question, right? You've got to figure out whether or not, if the manner of the death could in any way damage the structural integrity of the property. So without getting too ghoulish on it, I think you just have to understand that there is the exemption in the occupational code, but there's also these other considerations that you have to take into account from the seller's perspective, certainly.
And that might be one where we would say you may want to seek legal counsel.
I would always go down that road. And it's really common for realtors to try and, you're trying to take care of everything, but those are those areas where um, you don't want to wear the hat that could ultimately come back and bite you. Uh, that's one where it's not an expensive consult for them to talk to legal counsel, and it's more than worth it. So.
Awesome.
All right. Duty to amend. This one is always sort of a hot topic. The seller's disclosure statement in the act talks about in the event, I see a typo there, in the event of changes to structure, mechanical, and appliance items. So as to those other items on the form, it's only necessary that the seller believed that the representations were accurate at the time they executed the document. The other piece to this, of course, is that you can also create a duty to amend through purchase agreement. So contract can also include a duty to amend the seller's disclosure statement or a duty to disclose anything new relative to the property between the binding nature and actual closing. So those things should not be, I think, ignored. That sometimes people may want to keep the duty to update the seller's disclosure statement in the contract. And we've seen that on a growing number of transactions where people are more inclined to at least keep that trigger in place. If the seller says, well, we've disclosed it, but the contract says, yeah, well, if the roof leaks, after the purchase agreement has been agreed to, you've got to disclose that too. Structural might cover that, but at the same time, you want to make sure that your buyer understands the scope of the exemption, the scope of all the disclosures, and then, of course, if they want to mandate that it gets updated, there's only these few things that would trigger the update otherwise. So.
So let me throw out the one of the common scenarios. A buyer does an inspection, and as the inspector, there are signs of discoloration, the politically correct way of calling it mold.
Mhm.
Is now the seller, because of a buyer's inspection, now required to amend?
So the downside of this, and this is the emotionally unsatisfying part here. I, as the seller, could then have my own inspection done, right?
You're going where I wanted you to.
Yeah, and that's the problem that if I had to flag a weakness in the Seller's Disclosure Act, and I know that inspections and our home inspectors, very, very highly accredited individuals. There are many different certifications that make home inspection stand out. The issue, of course, is that it's not licensed in Michigan. That doesn't necessarily diminish the importance of it. In fact, it's more important than ever to find the right home inspector to make your arguments. But at the end of the day, when you're dealing with two competing inspection reports, that seller could ultimately stand on their bearings and say, "Hey, I appreciate what you found, but this is where I believe the truth lies," and stand behind that. Of course, any attempt to obfuscate or misrepresent the property is going to be a real tricky dance between seller and the realtor, right? Because oftentimes, the realtor is trying to be really hands off in terms of disclosure, but at some point in time during the pendency of this transaction, they're probably going to become aware of some information that may or may not be accurate. And that's where I think you got to really train up your agents to understand there's a demarcation point here that we cannot go along with, because then it looks like you're performing in concert with a misrepresentation.
And at that point, guys, you need to bring it forward to your supervisory broker so that they can take it to whatever level they believe they need to provide guidance not only to you but to your clients as to what the proper direction would be. So good stuff. Thank you, Brian.
Yes. So just to sum this all up, I think, from the buyer's perspective, and I've kind of interwoven some of the even listing side and the investor side into this conversation. So I don't think we need to belabor it. But when we're talking about why the seller's disclosure statement matters to buyers, I think we also have to kind of put it on a scale and say, it's very valuable, but nothing's as valuable as the inspection process. Nothing's as valuable as the period of due diligence that you set yourself up through contract to perform. Because at the end of the day, you want your inspection contingency to be ironclad from a buyer's perspective to say, if this property does not, staging and beautiful photos aside, if this does not meet the needs of my largest transaction that I'm probably ever going to make, I need to have all the tools at my disposal. And that's a big part of where the realtor comes in. I think the realtor who's representing buyers out there should be utilizing this as a technique to show value, because you don't want to be put in a position where you've got concerns, but it's too late, or you've got concerns and they're not protected through the inspection contingency because it was drafted in such a way where it didn't actually allow for you to actually use it for leverage. It's a tricky thing to kind of explain in the moment, but I think when you're having your initial consults with buyers, you want them to understand that you are the buyer professional who's willing to kind of get into the weeds on some of these things, making sure that the contract says exactly what you want it to say. And not all contracts are created equally, of course. That's where you have to be very mindful and aware of which geographic area you are. I mean, if you're dealing with the purchase agreement that's in one regional MLS, or it's your own that you have developed with the brokerage, you have to know your way around them, because if you're responding to something, or you're countering or trying to negotiate, you have to understand the operation of that change. So, all right. So I wanted to talk, if there are no other questions on seller's disclosure, Darwin, I wanted to jump to this, if that's
Yeah, I
okay.
didn't see any others in the chat. Well, let's take a few seconds, see if anybody's got questions. I always do my count, you guys. All right,
All
moving
right.
on.
So everybody remembers the acronym RESPA, the Real Estate Settlement Procedures Act. Um, Now, this RESPA about 10 years ago used to be pretty big news. Even going back to 15 years ago, because the CFPB, which was a relatively new Consumer Protections Bureau at the time, they held all the cards that they were judge, jury, and executioner on all things RESPA related. And what that means is RESPA governs the relationships between settlement service providers. So you've got, we'll just keep it simple here and say real estate brokerages, title companies, and mortgage lenders. And the list goes on to home warranty companies and anything else that you could arguably tie into the settlement of a transaction. The reason that this is sort of coming at us again as a bit of a surprise is that years ago, the United States Supreme Court um, basically said that the CFPB, as it was designed, had to restructure. It could no longer be this body that held all of the enforcement capability. There was no appellate process, and the appellate process was ultimately handled by the same investigatory body that brought the case in the first place. So they had to go through a significant restructuring. And then you also have the transition of power, depending on which presidential administration is in power. The CFPB has not been doing a lot of enforcement. So what happens is the plaintiffs bar, which is lawyers all across the country who will find plaintiffs that could make the argument that they were the victim of some sort of RESPA related law. And that means that if the regulator is not enforcing, that does not stop lawsuits from being filed, and dare I say class action lawsuits from being filed to enforce a law that's on the books, which is RESPA. So the reason that's important for everybody to understand is Section 8 of RESPA. And that means that it is a prohibition in that law that you cannot have two real estate settlement service providers giving value in exchange for referrals. So, you understand within our own profession, real estate brokerage, you can have referral fees between real estate brokerages. That's exempt. That's exempt under state law, and it's also allowed under federal law. But where we're talking about two different settlement service providers that are ultimately I'm sending Darwin, a thing of value for every number every client that he sends my way. That is a violation of RESPA when it comes to a federally related mortgage loan. Now, the reason why this was such a hot topic 10 to 15 years ago is there were situations where real estate professionals were becoming junior loan officers. They were getting partial ownership interest in a title company. They were becoming a title agent. All of these things were occurring. And I will tell you that there are legitimate reasons why those things can occur. The issue that we're seeing now is people are entering into agreements between settlement service providers, but the accusation from some of these lawyers that are filing lawsuits is that they're illusory, that they're actually sham agreements that are really just intended to create a sort of pipeline of referrals, and the thing of value that comes back is disguised as something else. So looking at it from a couple of different perspectives, when we think about joint ventures, this is where um, we get calls on a weekly basis from sales agents, but also broker owners who are trying to understand what their exposure is if it turns out that one of their agents has entered into a joint venture and done it in a way that's not proper. Because the liability concerns, not unlike with fair housing law, there are vicarious liability concerns with RESPA. At least one case out of Pennsylvania has found that if you have a role in supervision, if you are supposed to be you're supposed to be aware of how the trains are running and how the arrangements are with all of your affiliated licensees, you could have liability when it comes to any kind of setup. A joint venture would be the example where they are alleging that they've purchased an ownership interest and that they're paid on the basis of that ownership interest. But fast forward, spoiler alert, what we're finding is that more and more the pitch is, yeah, here's a way to acquire an ownership interest, but it's largely tied to how much volume of referral that you are engaging in. So when we think about Section 8, anything of value. It doesn't have to be cash money. It can be concert tickets. It can be trips. It can be anything that represents consideration in the eyes of the law, which the Supreme Court has made it very clear that it's extremely broad. So when we think about what an actual rule map would be to satisfy an affiliated business arrangement or joint venture, these are sort of the four hallmarks that I would bear in mind. And this is important for supervising brokers. This is important for team leaders. This is important for agents that are being approached by title companies that may or may not be explaining it as clearly as you'd like. So first rule of thumb is that a licensee cannot be paid based on the volume of business they send to the joint venture company. The only compensation that they can get from that joint venture company is a share in the overall profits. So we think of the ownership interest that they have acquired in that company. So I've out of my own pocket purchased 1% in a company. I can be paid on the basis of that 1%. And then I cannot require my clients to use that company as a condition of the sale. And then the client has to sign an affiliated business arrangement disclosure form, which discloses the nature of our business relationship. I've said it twice, relationship, with that joint venture company. And then, of course, that company has to be legit. This is the other accusation that the CFPB was really wrangling with back 15 years ago, is they would see these companies pop up and argue that they were in fact a legitimate business, but they were not capitalized. They did not have office space. They did not require core services to be performed by the junior loan officer or the title agent. It was what they called a sham arrangement. So if you can evidence the four things that are up here, you are very likely operating within the safe harbor of the affiliated business arrangements under not just HUD, but CFPB as they've taken on enforcement. The downside to this, of course, is it's not stopping the lawsuits. So what you're seeing now, and there were three, there are two pretty massive class action lawsuits out there that are seeking certification and trying to withstand summary dismissal. One of them is with Rocket, and the other one is with Veterans Home Mortgage. The one that just settled was with, it didn't settle, it actually was dismissed, was Zillow with their preferred, I can't remember the exact name of the business model, but essentially arrangements where you're paying more to appear more prominently on the site, and also a referral mechanism therein. But the issue that I sort of have as heartburn here is that even if you're doing all of these things, the firms that are getting involved in these lawsuits right now are the same firms and derivations of the firms that were involved in the Sitzer-Burnett case. So Sitzer-Burnett was obviously the one down in Kansas City where compensation through the MLS became a huge issue. The jury actually found in favor of those plaintiffs. And there was a companion case up in Illinois called Merle, which ultimately got settled into the Sitzer-Burnett case. But I guess my point to even bringing those two things up is in both of those instances, you had contracts, right? You had contracts with your sellers where they agreed to cooperating compensation. They agreed to the mechanisms in which it was going to be provided, and it was not in any way outlawed by state law or federal law. But the jury still found in favor of the plaintiffs. So my concern here is that you've got all of these different settlement service providers working together. In most instances, I would say that the goal of these sort of relationships should be to all boats rise, right? The client gets the benefit of probably cost savings, and the businesses have the benefit of actually working, in concert with people that they can trust. The downside, of course, is that any of these things get to a jury trial or a certification, and they start to look at whether or not the engagement as a joint venture served the purpose of the client. That's where I start to get concerned because we saw how that narrative played out in Kansas City. It didn't look great. It looked like that this idea of cooperative compensation or any number of sales approaches was in some way deceptive, and you don't want to have the same type of narrative affixed to this. So when we think of your agents that are out there approached by title companies or mortgage brokerage to engage in some joint venture, I think it's really important for not only the agent to make the brokerage aware, but for the brokerage to have a policy in place on how this all operates. Because you don't want to be caught unawares in a situation where the allegation is that you're claiming you have a joint venture, but we don't believe that the agent acquired it through actual investment in the business. Or you claim you have a joint venture, but we don't believe that it's not based on the actual referral of business that's impermissive under Section 8 of RESPA. So those types of things you always have to be aware of before it's too late. And I think in a lot of instances, based on some of the conversations we've had, a lot of agents are getting approached. They don't necessarily think about even running it by their broker because it's maybe a different company altogether. The downside, of course, is that they need to understand the brokerage under occupational code has a very specific supervisory role. And some of the courts out there are looking at this from you have to be aware of what your agents are doing. And if they're out there engaged in joint ventures that may or may not be legitimate, you have to know the lay of the land in order to make it work. And some brokerages are adopting policies and procedures that support it. And that's great because that means that they're kind of digging into what the risk could be and understanding what type of policy needs to be in place to make sure that there's no disconnect between communications. But again, I just get nervous about, what's the next big thing. And the last big thing was, of course, the listing side compensation dispute. And then it gave way to a bunch of copycat lawsuits that were on the buyer side, arguing that buyers lost the ability to negotiate their compensation piece. Of course, the reason that got awkward is because most of the time the buyer was financing the transaction. And of course, the listing side was agreeing to pay a specific amount, all agreed to in contract. So my fear, of course, is that we can paper over everything. We can have contracts that we think are ironclad, but if one of these gets away from us and we start to see cases getting certified that look at the relationships between settlement service providers and where RESPA stands, we could have some pretty significant consequences. So I think the only way to combat that right now is to make sure brokerages are not turning a blind eye to it. I think you got to have a policy in place to say, okay, what's the lay of the land on our agents that have joint ventures? They can be perfectly legitimate, but if you don't have a policy in place, it's really hard for you to make that claim. So, any
So one,
questions on
yeah, a couple of things,
yeah?
Brian. One, I wanted everybody to know, excuse me, you may hear the term JV.
Mm-hmm.
That gets dropped a lot as if we all know and understand what that is. If you hear the term JV, then that individual is talking about a joint venture.
Right.
So that was one. I didn't want to just have that. We've got a number of newer individuals with us. And then regarding the aspect of any form of consideration, does client data or homeowner information count as something of value, that form of to go along with that?
You know, it hasn't been presented in a way that I could say definitively that it is, Darwin. But I think that we're in a world right now where it's pretty clear that data has value. And we're in a world right now where likes and shares on Facebook certainly have monetization value. So I don't take anything for granted. I just think that the biggest I think hurdle for us to clear here is how much are we communicating? And we're getting approached to do JVs, and we're getting, and I know that it's a competitive thing too, right? You want to be some brokerages don't want to address the situation because for fear of that so and so is going to go down the road and at a brokerage that doesn't concern themselves with it. But I don't think that that's a solution. I think that ultimately one of these cases, we'll find out where the courts go with it. But if one of them, catches, attention and gets certified, and then you've got a jury considering it, I don't know where that goes. So, this case out of Maryland at the bottom here, they had in exchange for referrals from a mortgage company, a title company would make payments to the marketing company, and it was sort of like applied to their company's account. They tried to call it a sort of a marketing services agreement, but ultimately the court viewed it as a sham, and they thought that it was attempted to conceal illegal kickbacks as co-marketing. So when we think about, even if it's not, I'm being hired as a junior loan officer, or I've got a part ownership in this company, the joint advertising and the communication between the company, that all has value too. So you have to be mindful of some of these things from sort of a 30,000-foot perspective. But I think the biggest downside right now is that I 15 years on, I think a lot of us have forgotten about RESPA, don't view it as a threat. And as you mentioned, Darwin, a lot of folks are coming into the business anew, so they've never thought about it. And I do think that it's one of those where there's a reason people are suing under it, because it can come with attorney's fees. It can come with a lot of bells and whistles that make it desirable to actually pursue. And again, these are not people fresh out of law school bringing their first lawsuit. These are really well-funded law firms.
The government pretty much wants us to make our money off of selling real estate and getting
Yeah,
our compensation from that duty.
yeah, I think so.
So if you think that you're trying to find a way to be able to get income from any other source, it's probably not going to work.
Yeah, I just say, and I think that's well said. I worry about the nature of the law, because it is so flexible in a lot of ways, and we talk about safe harbors that get presented by regulators, but that doesn't always translate to what a jury would say. So,
Good deal.
but any questions from the folks out there in Zoom land?
Feel free to come off of the mute if you've got something. Are we kind of open now also, Brian? What do we got
Yeah,
here?
yeah, I'm at that spot now where I'll stop sharing and see if anyone wants to chat.
So, well, we've got, I think, Brian, 7 minutes, at least by my clock, but I don't know how your day is. But guys, open for any question that you might have from the things that you're running into out there.
Darwin, I have a question.
Shoot, John.
So, Brian, my question is regarding arbitration. So, my question specifically is if a brokerage's own custom purchase agreement cites the old repealed MCL 600.5001 instead of the current MCL 691.1681 in its arbitration clause, and that it did not require an opt-in for initials, with initials or signatures, does that make the clause unenforceable or ambiguous, or is it still binding to compel arbitration regardless of which act it names?
Yeah, no, that's an interesting question, John. I think you're probably going to ask it to 5 different attorneys and get the same emotionally unsatisfying attorney answer of it depends. The issue, of course, is if it's a statutory reference that's been updated or it's been truly amended. I think that opponents of the arbitration are going to try and use that in their favor. But ultimately, I think when a judge looks at the four corners of the page, they're trying to put the parties in the position that is most evident of their like-mindedness, right? So what they agreed to, and if it's a Scrivener error or if it's a failed update, I think that would be the alternate argument. It would be, I think that this is what the parties intended, so therefore go forward. Nowadays, I think, when we talk about things like procuring cause, and NAR has been working hard over the last several months, even over a year now, to try and harmonize what we've always understood in arbitration disputes or even procuring cause disputes as arbitrable. And I would argue that moving from a metric where you've got compensation and cooperation agreed to within participants in the MLS and moving it off MLS, it really comes down to how strong the contract is. So your point, I think, is well taken, that if you're utilizing a contract that has ambiguity, or you're utilizing a contract that you don't fully understand, you do so at your own peril. But I'll be honest, John, I don't know exactly how that would turn. I think ultimately those two different counter arguments are probably what would start the process.
All right. Who's next?
I have a question.
Go ahead, Terry.
So I got on a few minutes late, so you may have covered this, but when you have, obviously you have a homeowner who's selling, they will do the seller's disclosure. You have a person who is acting like maybe it's their parent passed away and they're acting as the trustee or fiduciary. I understand that where there can be like the seller's disclosure, there's another form, right? You can fill
Well,
out.
the non-occupant fiduciary exemption would be the argument that, but again, as Darwin kind of raised this as a stress point earlier on, it is one of those where your client may well think that they fit squarely within an exemption, but I do think it's important for them, not to rely upon your assertion that, yep, you're good.
Right.
That if they're going to be going down that road, you don't want to be the brokerage that says, oh yeah, sounds good. They should talk to legal counsel, especially as it relates to not furnishing or claiming the exemption, because we know the downside, of course, is they have a more complex process if they want to claim a breach of contract, or
Right.
they want to claim that the buyer walked from the transaction without course. So,
And then the other thing I have seen is where like a parent and the child are on the house together, so that when the parent dies, they're already sort of an owner. They're not going through that process, but because they haven't lived there, they claim, I've seen like,
Gee, I don't know anything.
yeah.
yeah,
So in
Yeah.
this case, they would fill out the seller's disclosure statement, and to the best of their ability, not unknown, and then where it's like the seller has lived in the residence, is that where they kind of indicate that it's
yeah. I think
inherited
that
or they never lived there?
I think that that's important, and I think I mentioned it earlier. I was just, a lot of times when I think of the set, like from even an investor's perspective, or I don't think there's any reason with a seller letting the buyer know that they have owned the property for a brief time, or they grew up in the property, but it's been 25 years since they've occupied the property, right? So I think it just reinforces the argument that we made from the outset, which is buyers need to be really well coached on this, that the seller's disclosure statement is only as good as um, the information provided. If it's scant at best, they need to be doing the inspections. They need to be
Okay.
going all out if they want to keep that transaction alive. But to your question about whether or not that's going to be a solid hook to hang your hat on for the purposes of claiming an exemption, I think that's where they've got to have a conversation with their legal counsel to say, okay, you're not truly a non-occupant fiduciary. Or you've lived in this property in such a way where I wouldn't be comfortable supporting that claim.
Okay, thank
Yeah.
you.
So, guys, with that, Brian, I'm going to let you wrap up if you got anything.
No, hopefully, if you haven't planned it out in your schedule, hopefully, you're all some of you are thinking about coming up to Traverse City area for convention. That's always a good time, and we've got a fun legal update, and we've got more Con Ed than you know what to do with up there. Really emphasizing legal Con Ed and some great stuff for you to actually employ in your business. So. Happy to chat with you guys in the future. Please include me in these whenever you think of it.
Awesome. So, Brian, thank you. Fantastic and awesome information. Guys, as always, remember this will get posted up to the HRC Agent Development channel. Remind others that it's there. And with that, being respectful of everybody's time, thank you all. Thank you again, Brian. Gang, until next time, have a great week. Go talk to people. See ya. Thanks again, Brian.